Let's give the people what they want. Can you read your letter of what you're sending to the ATF or have sent to the ATF?
Yes, this letter is hopefully delivered as we speak. Dear Director Dettelbach, as the elected sheriff of Polk County, Wisconsin, and the guardian of my citizens' constitutional rights, I am writing this letter to inform you that the recent rule change pertaining to pistol braces is government overreach. This is unconstitutional to allow my citizens for over 10 years to purchase this type of firearm, and then with the strike of your bureaucratic pen, potentially make my citizens felons. Polk County is a Second Amendment sanctuary as of May of 2020. I will not allow your tyrannical government agents to victimize my citizens. I stand ready to defend the rights of honest, law-abiding residents here in Polk County. I will take no enforcement action on this rule change or allow any federal agent to take action against my citizens. I strongly recommend you cancel this recent rule change as this is a clear violation of the Constitution. You are in violation of your oath of office, and now we the people lose all trust and faith in your ability to do your job.
You characterize this as government overreach. You characterize this as being unconstitutional. What do you see wrong in this? Help folks who maybe are just coming up to speed on this. What's wrong with this?
The thing that really bothers me about it is the strong rulemaking ability that this bureaucratic agency has. The ability to, with a strike of a pen, potentially make me or another citizen a felon without any legislative process, without any, I'll just say, due process. This is too much power for one entity. You know, to me, it goes into this checks and balances, which is how our government is set up to operate. And this is clearly giving one agency way too much power.
What makes this transform from being something that's unsavory and wrong to tyrannical?
Well, I see it as it impacts so many people. I mean, this is not some obscure device. There's millions of these in circulation. So millions of citizens around the country have these. They were told they could do it. The fact that it goes retroactive is very troubling to me. If they wanted to say at this point, from this point forward, you can't have this, but the people that have them, you're grandfathered in. There's people that may not have access to the internet, people that may not be aware of this rule change, and to have such a quick, 120 days to get this right, or you could potentially be facing, a federal felony. That's extremely concerning.
A big question that I saw where you say that I will take no enforcement action on this rule change or allow any federal agent to take action against my citizens. So federal agents show up. They get a tip off that someone in your jurisdiction has one of these devices, a pistol brace attached to a pistol. We're post 120 days from the registration, amnesty issue and all that kind of stuff. ATF comes knocking in. You get the call from them asking for local cooperation. What do you tell them on the phone?
I'm going to tell them that I believe this is an unconstitutional order and that they're in breach of their oath of office to take action on this. In the past, our county, we're a small rural northern Wisconsin county. We've worked with federal agents in the past. If we have a bank robbery, the FBI has assisted. If we have a large drug case, we've had help from, several federal agents. It's always been a pretty good relationship, and we've worked as a team. This is not going to be a situation like that. And I always like to share the story how I bumped into an ATF agent right after we had a change of office in Washington. And I told him while I was in the gun shop that, hey, if you're coming here to ever enforce an unconstitutional order, whether it's by the president at the executive order level or something to this effect, you will not be welcome here. In fact, we are not going to work together. And it's, I don't want to ever see a situation where in some standoff with the federal government. I would hope that calm heads prevail in a situation like that they would back away from a situation. But I would certainly be very clear that as the chief law enforcement officer for Polk County, I don't agree with this. And it's a breach of your oath that you've sworn to uphold the Constitution, and you're violating that. And if they were to take heavy-handed action against a citizen, I would view that as a potential misconduct in office, an abuse of power.
So let's go there. You get a 911 call from a citizen. that I've got ATF agents at my door. They're saying they've got a warrant and they're going to come in to get my pistol brace. And what is the Polk County Sheriff's Department going to do?
Well, I would certainly try myself to respond and intervene, and certainly tell the feds that we don't enforce this here. And again, I wouldn't want to get into an armed conflict with the ATF.
It's a good day for no one.
Right. I would really hope that prior to this, that we get some type of a stoppage in the courts. I mean, this is wrong on so many fronts. I would think that attorney firms are lining up to file a lawsuit against this.
Are you going to be arresting or blocking or removing the federal agents if they insist to push the issue?
Well, I know in other parts of the country, sheriffs have stood up and said that they would in fact arrest a federal agent for doing something that was extremely unconstitutional. And I guess if we got to that point, I would certainly consider that, absolutely.
I can hear folks saying, why not wait for the courts to figure this out? Why not wait for the legislatures to react? Why does this have to be enforced at the law enforcement level?
Well, it's interesting. We see this in other areas when there's a new rule pertaining to hunting and fishing. It's not strictly enforced initially. There's usually a period of public education. And I don't see that with this. I see this as the line in the sand is 120 days. You have that amount of time to fix this, and if you don't, you're risking prison time. And that's concerning. The reality of it is, I'm a strong advocate for the Second Amendment. First and foremost, that's my priority. And I tell my staff, if we encountered one of these things used in a violent crime, there's already the laws on the books for armed robbery and homicide and everything else. It isn't this, now we got you with a pistol brace. This is a realistic part of, I don't have any problem making arrests for people that are committing violent crimes with firearms. I have a problem with the government targeting the honest, law-abiding citizen who went through a background check to buy this firearm, typically at a new gun shop or at a gun shop when they buy this new item. They're subject to that background check. Now they have to worry that, what do I do with this thing? And what if you're not tech savvy? What if you don't know how to access that ATF website? Internet problems in my county. I'm a rural county. That's one of the priorities for my county the last 2 years is to expand broadband internet service. There are still people that choose not to have internet and live out in a very rural, simplistic life. And they're also firearms enthusiasts. They're putting themselves at risk when we impose a law like this. And it's not a law, it's a rule change. They're changing the rules. I find it to be unethical for a law enforcement agency like the ATF, part of the Department of Justice, to pass a rule that allows people, 40 million of us, to buy these things. And then overnight it's changed. It's like it's a form of entrapment. Hey, go ahead and buy this. Now that we got enough of them out there, now we change the rules and we can make you all felons. I find that to be just in very poor taste.
What is the solution in your mind? Is there a solution in your mind to make sure that this doesn't keep happening?
Well, I think the power of the ATF needs to be rolled back. I think the courts need to recognize that they have far too much power. I think the solution lies in, the fact that any rule change should never be retroactive. We saw that in the old assault weapons ban. You brought up the assault weapons ban, but back in 94 to 2004, in that 10-year period, if you had a gun that was in that ban, you were grandfathered. And it actually increased the value of your gun. It was a pre-ban gun. And they just simply said you can't buy these from this point forward, but those of you that have it,
Right.
You now have a more valuable collector item. So I think that's the part that causes a lot of pain for most people is this retroactive angle where it's, we allowed you to do it, and now you're stuck with this thing and you're really wringing your hands. What do I do with this?
And guys, I'm just going to pause this video really quickly to ask you to please show your support for both Sheriff Waak and the Second Amendment by clicking like on the video. Of course, I'd ask you to please subscribe to our channel if you want to see more interviews like this, as well as to support our growth. And of course, please share it around social media. That's really one of the best ways of helping us grow. Let us know in the comments section whether or not you stand with Sheriff Waak and how you think this would turn out. Now back to the program.
In my close to 30 years of law enforcement, I don't know that I've ever seen somebody convicted of being a felon in possession of a firearm. When we do a drug raid and we find a felon that is in possession, it seems like those always kind of get pushed on the back burner. Always in some plea agreement that charge gets pushed away. Very few times has the federal government ever stepped up and taken a gun case when we've thought we had a good one. We caught a violent felon with a firearm, and we wanted the federal government to take that case. They've been very reluctant.
Can you speak to, in a more rural setting, what kind of firearms? And I mean bad guys. I don't mean good guys who, like, they had some sort of mischief they got caught up in as a teenager. Now they're 20 years on. And they've been paying taxes, raising a family, and so forth. I mean, like, you mentioned drug dealers, and I'm talking like bad actors, right? What kind of firearms do you see them get? What kind of firearms do you see them choose to have? Do they seem to know their stuff? Do they not seem to know their stuff? Can you speak to any of that? Because I know folks are curious.
Well, as you know, the firearms that interest me come with a high price tag. Many of these firearms are upwards of $1,500 and on up. Those are not the firearms we encounter when we talk about our county is rural. We have a big substance abuse problem. We're situated close to Minneapolis, so we have a lot of drug trafficking. And so we see a lot of handguns. And there's been an uptick in that since COVID, that a lot of these drug dealers are running around with a handgun, and it's usually a low end. It's not a high end, high brand firearm. It's a more low end semi-automatic pistol typically.
Sure.
But it's we did have a guy that had an old Norinco Uzi in the back of his vehicle. That was kind of out of the norm. We usually don't encounter that type of a weapon. It's usually just a cheaper handgun.
Cheaper handgun, loaded. Do they even have hollow points or the ball ammo?
Yeah, usually just, off the rack ammo, cheaper ammo typically.
Plinking ammo is what you and I might call it.
Right.
Right. What percentage of those firearms do you think actually work? Like if you took it to the range to fire it, half, 3/4?
Well, I would bet most of them work.
Okay.
I would bet most work, and I think they've probably test fired them, and but it's ironic. We've had in the last couple of years, we've had shootings that were never even reported to the police. We heard this through other people that this person had been shot in a drug deal, and we've had to backtrack, and we find, here's a car that is all shot up, and then we've tracked down a person, and has the slug that he dug out of his hip. And
wow.
We've got convictions on those. And so it's ironic to think that here you would have this shooting, and it was never even reported. It was through word of mouth we learned of it, and then my investigator group had to work that case backwards to figure out what happened, and certainly we got a conviction on those cases as well. But so I think they do have functioning firearms, and
right.
I don't see rules like this having virtually any impact on changing how crime is in our country. The biggest impact this has is to the honest person who goes out and enjoys sporting firearms, shooting at the range, and has walked into their gun shop and said, "Oh, that looks interesting. What is that? Oh, it's perfectly legal to buy this. Here you go." And now 10 years later, now you're sitting with this question, what do I do with this?
If you were given somehow, some way, the power and the authority to reshape how law enforcement, how everything works, because we always hear it all the time. The politicians are saying, whether it's Illinois or wherever else, hey, we've got to get guns off the streets. We've got to do this. We've got to do that. We've got to pass all these gun control measures. In your experience in 28 years in law enforcement, is that moving the needle in any real way in the actual trenches of what you see?
Absolutely not. And everywhere you look where there's strict gun control measures, crime is in the highest areas, violent crime especially.
You don't, and I think I know the answer to this, but you're not alone in that feeling. If I were to talk to other law enforcement officers, other sheriffs, police, and so forth, maybe not the politician types, if you will, the people who have to respond to a board or the mouthpiece for a mayor or something like that, but do you think this is a really pervasive feeling, or do you think, no, there's only maybe 5 or 10% of us who see it that way?
I don't know on that one. I think that the pulse of the street cop, they're very in tune with their citizens, and if they do their jobs right, they have a sense of what their community is feeling. And I think that's where this disconnect, there's a great divide in our country between rural and urban, and you see it in many areas, just in what people do for recreation. And those conflicts seem to be getting larger and larger.
Right. Do you see that changing anytime?
I don't. I think the divide's getting greater. There's a big difference in just how the citizens in an urban area view the police compared to the citizens in a rural area. And I'm very fortunate. I always tell people in Polk County, I feel like there's a storm around us, and we're in that calm eye of the storm. I don't have to look far to see turmoil in policing, but we don't have that where we are. We have the pulse of our citizens. We have the trust and support of our citizens, and we work really hard to do that.
Anything else from your end that you want to go on the record with here today?
I really hope that no matter what side of the political spectrum people are on, that they look at this and see that this is overreaching government, and that this should be a red flag, because these types of heavy-handed rules could be applied in a lot of other areas. So this really is about doing what's right.
And it's that simple. It's just the difference between what's right and wrong.
Exactly.
I want to go out on a couple fun questions. Favorite handgun brand, if you have one?
Well, I like Glock, and I got to tell a story, and it kind of goes back to an assault weapons ban, but I went to the police academy in 1994, and the gun ban went into effect, and I needed 3 magazines for my Glock, and it only comes with 2. Well, this assault weapons ban went into effect, and you could not get large capacity magazines. And so I was going to get bounced from the class to fire them. They weren't going to allow the firearm because I couldn't find a third bag. They were sold out nationwide. People were paying like $100 a piece for them. Well, I was a fresh out of college kid. I didn't have $100 for a magazine. My instructor said, I know a rep from Glock. Let me reach out. They mailed me 5 magazines, a hat, and a bunch of stickers. And so from that point forward, I've been a big Glock fan. I thought, what a great way to take care of a new law enforcement officer. And I had put myself through the academy. I wasn't sponsored. It was just Brent Waak, the citizen, going to the police academy. And for a company to reach out to me when they could have easily sold those mags for $100 a piece, they dropped 5 in the mail for me. I thought, what a great company. But there's many. We do carry Glocks at the department, at the agency. So I've always been a Glock fan.
Favorite rifle brand for hunting? You mentioned that you're a hunter.
Well, it's interesting. I carry a lot of different guns when I go hunting. When I go up north.
We're trying to keep it under a 3-hour video here.
Yes, I was going to say, I like Browning for a traditional hunting rifle. I like Winchester for a traditional hunting rifle. In fact, I have a Winchester hanging on the wall in my sheriff's office because I think every sheriff ought to look at the heritage of America, and Winchester is hung in a lot of sheriff's offices.
Model 70, I assume?
No, it's a Model 94 lever
Okay.
gun.
All right.
I got it hanging on display.
I didn't even know I didn't go back that far. So 30-30?
30-30.
Fantastic. Pre-64?
It's a commemorative. It's a legendary lawman commemorative. So, but that's the thing that upsets me so when I hear that, the AR is a terrible hunting gun. It's actually a fantastic hunting gun. For coyote hunting, it's probably one of the best. And so I frequently carry an AR when I'm out in the woods.
AR-10 or AR-15?
Both.
Favorite calibers for coyote hunting then?
Probably .223.
Just great ammo, works all the way around.
Yeah, and it does a nice job. A long range, very nice weapon.
Favorite shotgun brand, if you have one?
Well, I was Benelli for the longest time, and then I went to a Browning. So
you're syncing up into just a couple brands then, is what I'm hearing.
Sure.
Okay. Do you have a favorite ammunition brand?
Yeah, ammo has been so difficult to get. I would say whatever is in stock is my favorite brand.
That's not the wrong answer, that's for sure. Fair enough. And then any particular favorite holster for concealed carry brand?
No, I don't have any preference on that. Just whatever feels comfortable.
Well, hopefully one of these companies will see this interview and you'll get a new call from a new rep who will want to take care of Wisconsin's favorite sheriff. So, Sheriff Waak, really appreciate you coming in here today. Hopefully we'll see you again soon.
In this case, ATF has essentially just completely rewritten federal law. What ATF has basically said is nah, we're just gonna say here on a whim that we think you actually are intending for these to be, whether you designed them or made them, we think you did because we want to regulate them. So we're gonna imply that with a rule, hold you criminally liable if you don't register your firearm.
The new ruling from the ATF now says that attaching the devices to pistols is a felony, punishable by up to 10 years in prison. The Congressional Research Office estimates that there may be as many as 40 million devices now in circulation, resulting in a constitutionality crisis manufactured by the ATF by moving the goalposts on millions of Americans. There are no provisions for grandfathering, and many Americans in many states have no options other to effectively destroy their devices or turn them in. I was privileged to sit down with one of the lead attorneys, Lucas Vebber, from the Institute for Law and Liberty, to discuss the case. So you know why you're in here today, but the folks down the lens maybe have a little bit less of an idea. What's going on?
So a couple of weeks ago, the federal government promulgated a new rule purporting to reclassify every pistol that has a stabilizing brace on it as a short-barreled rifle under federal law. This has significant regulatory ramifications for everyday Americans. Up to 40 million Americans, their estimates about 40 million that could be impacted by this. It's a tremendous change and something that most people aren't even aware of.
And let's just kind of quickly set the stage. Are you able to register an SBR in every single state? Is an SBR lawful in every state, or does it only work for certain folks in certain states?
So states do regulate them separately. I don't know the individual laws in every single state, but states do regulate SBRs on their own as well. At the federal level, the federal government requires a tax stamp, a $200 stamp purchase before you can lawfully own an NFA firearm. It also has to be registered in their federal database. And then once you have it, ATF takes the position that only you can fire that firearm. So as the registered owner. So if somebody else wants to shoot your gun, they can't if it's an NFA firearm.
So, of course, as you know, many folks in many different states have no ability to register under this because it's illegal to register. I mean, certain states just non-starter. New York, Illinois, California, New Jersey, just to name a handful. So folks who have these stabilizing braces in these states, which were purchased lawfully, they have no options here. I mean, they just have to throw it out. Is that right?
Yeah, that's correct. And in many cases, they purchased them lawfully. They purchased them with ATF's explicit blessing that these were not SBRs when they were purchased as determined under federal law.
So what has your group, and what group are you part of, by the way?
So I'm an attorney with the Wisconsin Institute for Law and Liberty. We're a public interest law and policy center based out of Milwaukee, Wisconsin.
And what kind of work do you guys do?
So we bring cases to support our mission. Our mission is to advance the public interest in the rule of law, constitutional government, individual rights. Wherever government is overreaching and it's to the detriment of everyday citizens, Will wants to be there to bring that fight to the government.
So you guys, of course, are representing a handful of people now. You're suing the Biden administration. Who else are you suing about the pistol braces?
So we've just named ATF as our defendant.
Okay.
We have three plaintiffs. They're all veterans who have stood up, taken an oath to defend our Constitution, to defend our country. And they're all now standing up to fight back against this unlawful regulation that ATF put out.
And what specifically is your lawsuit saying that they got wrong, they being the ATF? What kind of remedies you're looking for, just that kind of stuff?
Yeah, so the remedy we're looking for is just to have the rule completely set aside, right? So the federal law allows us, if a regulation is unlawful, it can be set aside. So that's what we're asking the court to do. The reason that we're able to argue that it's unlawful, we make constitutional arguments. So first, this regulation infringes on the Second Amendment rights of our plaintiffs. And secondarily, the rule amounts to lawmaking. It violates the constitutional separation of powers because here you've got federal bureaucrats who are unelected, are not members of Congress, who have essentially rewritten a federal law. Beyond those constitutional claims, we also have statutory arguments under the Federal Administrative Procedures Act. We make statutory claims. For example, when a federal agency decides to change its mind on how it's regulated something for a period of time and change its mind, there's certain things they have to do. One of those things is just acknowledge that they're actually changing their mind. Here, ATF doesn't really do that. In their rule, they go out of their way to say, no, there's a lot of uncertainty. There hasn't been a clear rule that's been in place for 10 years, and this rule just clears up the uncertainty. And we think that doesn't meet their obligation under the law. We also think the rule itself conflicts with federal law. It conflicts with the definition of a rifle because it purports to redefine things that are not and cannot be rifles as rifles under federal law. And Insofar as it does that, it conflicts with the federal statute.
Thank you very much for sticking with us so far. There's a lot more great content coming up. Please show your support for not only this channel, but also the Second Amendment and the Institute for Law and Liberty. Click like, share this video around, click subscribe if you want to see us to be able to get more interviews like this one, and on with the show.
We filed this lawsuit a couple of weeks ago. Last week, we moved for what's called a preliminary injunction. We're asking the court to set the rule aside while the merits of the underlying legal issue are litigated.
So last week being first week of February, that's when you've asked for the preliminary injunction. And we're going to keep going to the list of all the other great things you mentioned, but that's going to be super important, asking for that injunction.
Yes.
So let's actually tease that. We'll get back to that in a moment, all right? So what are some of these constitutionality issues that you're looking at? How do you feel like the ATF has violated the Second Amendment?
Yeah, so just last year, the U.S. Supreme Court handed down a decision, New York State, pistol and rifle versus Bruin. In that case, the Supreme Court struck down some regulations that violated the Second Amendment. And in doing so, they said that whenever federal agencies are attempting to regulate firearms, that the Second Amendment is triggered. It's an individual right that you have to possess a firearm. And when they do that, they have to look at the historical regulation of firearms, and they have to explain why the tradition and the history of firearm regulation supports their regulation. ATF didn't do that for this regulation. They simply said, no, pistols with a stabilizing brace are short-barreled rifles. Short-barreled rifles have been regulated, therefore we don't have to worry about going through that analysis. But that's wrong. They missed the step. They have to explain why pistols with stabilizing braces have historically and traditionally been regulated as a firearm under the NFA, and they simply can't do that. So our legal argument is that violates the Second Amendment. It violates what the court said in Bruin. And it should be set aside. I think part of what ATF's position here is going to be is that a pistol brace is just nothing more than a shoulder stock. That's going to be their primary argument. So that, yeah, this particular device was invented in the past 10 years or so, give or take, and became into heavy use over the past decade. But really, it's just a stock, and it's just a stock by another name. And stocks have historically been, regulated, or at least not the stock itself, but associated with a rifle, and that's kind of how they'll try to get there, I assume. But again, it's a little too early for me to be able to say one way or another, except based on what we've seen in their rulemaking document, which is a couple hundred pages long, and they try to set this stuff out. But the primary argument they made in there for why they don't have to do the Bruin analysis is just because they say these are SBRs. SBRs have historically and traditionally been regulated. Therefore, they're dangerous weapons, I think they call them, and dangerous weapons don't fall under the Second Amendment.
And of course, something else that you brought up before was the ATF is claiming that somehow the fact that you have let's just call it a rifle for now, although I hate doing that. But at any rate, regardless of the overall length, regardless of the barrel length, somehow it becomes more lethal or more dangerous.
Exactly.
Can you speak to that at all?
Yeah, I mean, again, that kind of they attempt to sort of make that argument that this becomes a more dangerous weapon, which then in their minds makes it outside the scope of essentially Second Amendment review. But again, I don't think they've met their burden of showing that. I don't think they can meet their burden of showing that. Here you've got millions and millions of law-abiding Americans who own these devices, who use them every day without incident. It's simply ludicrous for ATF to argue that. They will, of course, argue that. I don't think that the argument is a good one. I don't think it's based in reality, and I don't think a judge is going to buy it.
So, of course, what we're talking about here is rulemaking, right? Because the ATF, although they may think they can write laws, but they can't. They're a federal agency. They can write rules. Rules are not laws. These are different. Rules are interpretations of the law, right? Congress will do kind of big picture stuff, and then agencies step in to fill the gaps. But they can step in to fill the gaps without creating new gaps, without creating new lines and so forth. Is that a fair way to understand what we're talking about here?
Yeah, I think so. I mean, I think most people understand that, we see the Schoolhouse Rock video and we learn about it in fourth grade. We know that Congress writes the laws, the president enforces the laws, the judiciary interprets the laws, but there's also this federal bureaucracy that's kind of the fourth branch that's out there that takes these laws that are written and decides to just kind of write some more on top of it. They, in many cases, in all cases, have essentially the same force and effect of law. You're bound to abide by them, or you could be subject to penalties under them. but they're not written by elected officials. They're written by agency bureaucrats, people who have never stood for election, people who no one's probably ever even going to meet or know who they are, and they're accountable to essentially to no one. Congress has some limited oversight powers, but it requires a rather Herculean effort for Congress to get involved and to overturn these rules. In this case, ATF has essentially just completely rewritten federal law. So Congress has said in the NFA and in the Gun Control Act that they're going to regulate rifles. And rifles with barrels less than 16 inches could be could be subject to the NFA. But a rifle is defined as a firearm that's designed, made, and intended to be fired from the shoulder. So you have to meet all three of those requirements. What ATF has basically said is, nah, we're just gonna say here on a whim that we think you actually are intending for these to be, whether you designed them or made them, we think you did because we want to regulate them. So we're going to imply that with a rule and hold you criminally liable if you don't register your firearm.
So you originally sketched out four ways, four kind of thrusts what your lawsuit is. We dealt with the Second Amendment, that this is a violation of the Second Amendment. We talked about this as being an overstep of the delegated rulemaking authority. And of course, you and I can disagree with how much delegated ruling authority they should have. Mm-hmm. But we're talking about the fact that, look, this is a clear overstep. And then we talked about statutory claims. Anything else that is the focus of the lawsuit here?
No, those are the primary ways that we are attacking it. So I think we raise all four. They're all sort of in the alternative, but the court could rule on all four of them. Courts generally tend to like to and have a preference for statutory claims. If they can avoid a constitutional claim, they'll rule on that. So kind of determine up to the court to determine if we win on any and which ones we'd win on. But we feel pretty confident about all of them. We think we've pled them well and we've explained them well, and they're all well within the case law and historical precedent.
So for folks who are curious, because I know that there's nerds out there who are going to say, why would a court prefer to rule on statutory? And I can make guesses based on my experience in criminal, i.e., it's just cleaner and simpler for them.
For sure.
Is that the same way?
Yeah, there's a judicial doctrine called constitutional avoidance, where judges will typically try to just avoid, if they can avoid deciding a constitutional issue, they will. If they can just do it on statutory grounds, it's not a requirement. It's not something that they necessarily have to do. Although courts will usually, if they can rule on a statutory issue and avoid reaching a constitutional claim, they always will do that.
Gotcha. So you mentioned before that you filed for an injunction last week, back in early February. Correct. What would that do if granted?
Yeah, so the rule itself is effective as soon as it was published, but it gave what they call 120 days of enforcement discretion. So ATF has said, hey, you can do one of several options to come into compliance, and we're not going to start enforcing this for up to 120 days or making you comply with it. So what we asked the court to do was, before that 120-day period is over, to set the rule aside while the underlying merits litigation plays out. So when you move for a preliminary injunction, you have to show a number of things. The most important one is that you're likely to win on the merits of the case. So it doesn't mean that you're going to win. The court just has to determine that there's some likelihood that you could win on this case. And if the court can determine that and determine that there's irreparable harm, there's other things, the public interest weighs in your favor, then the court can set the rule aside essentially temporarily while the lawsuit plays out, the underlying lawsuit. Many of the other factors for an injunction are essentially met when you have a constitutional issue like this. So it's a little bit of a different analysis. It essentially just comes down to the likelihood of success on the merits, although we argue all of them in our brief. But as a matter of law, what the PI would do was it would say that ATF has to set the rule aside, cannot enforce it at all, just presses the pause button while the litigation moves forward until the litigation is over.
If the judge does grant you the injunction, first off, when would that be? And secondly, would that only be valid for folks who live in the judicial district in Wisconsin that you filed, or would this be valid for folks nationwide?
Yeah, so our suit is filed in the Northern District of Texas. So we have plaintiffs in Texas. We have plaintiffs in Wisconsin. We brought the suit in Texas. In terms of how quickly the judge would issue it, don't know for sure. It's always up to a judge to make a determination as to whether or not the judge will grant it is entirely in their discretion. We would hope that a decision would come fairly quickly after it's been briefed. So we filed our initial PI motion. The federal government will respond to it. I think it's 21 days, and then we'll file a reply to that within 14 days, and then it'll be fully briefed. It'll be up to the court if they want to hear argument on that. The court could have us all come in and argue the motion in person, and then the court will make a decision on it. As to its applicability and how broad it would be, again, that's up to the court as to how far they want to extend it. Is it just going to apply to the states where our plaintiffs are from? Is it going to apply broader? That's actually a really interesting question under constitutional law, legal, administrative procedure nerds throughout the country as to whether courts can issue a nationwide injunction on a rulemaking case like that. And I think it's something that will probably come up in this case.
So how long is it going to take from now? So we're talking middle of February is when we're recording this. How long from now is it going to take, do you think, until this case has resolved one way or the other?
Complete resolution all the way through the courts. I think, depending on what happens on the preliminary injunction motion, if we win or we lose, or if, the government, there could be an appeal after that on the decision to grant or not grant a preliminary injunction motion. That appeal could potentially go, or it would go to the U.S. Court of Appeals, and then it could potentially go to the U.S. Supreme Court. Obviously, they don't have to take the appeal. They could decline to, but that would itself take probably through the end of the year, certainly into the fall. We're talking at the very least, and if the U.S. Supreme Court grants it, it could be into next year. Then, depending on what happens with the preliminary injunction, then the case would go back to the district court and for a merits decision, the underlying merits decision. And obviously, the outcome of the preliminary injunction proceedings will have a significant impact on the merits decision and could, in fact, be determinative itself. In many cases, that happens. So,
yeah. So, what you're saying is that, okay, so step one is the court will determine whether or not they're going to grant injunctive relief, i.e., are they going to press pause? And if so, what's the scope of that pause? That will be the first moment where either side can then appeal that to, I think it might be the Fifth Circuit Court of Appeals down there.
Yep, it's the Fifth Circuit.
Okay, so that's kind of step one, where in other words, the lawsuit gets put on hold, it goes up to the Fifth Circuit, potentially all the way to U.S. Supreme Court. And then based on how that turned out, and of course, I can imagine the rigorous constitutionality treatment of the issues in play, that may do a lot to shape how the case returns. Because I think what a lot of people get wrong, and I want to make sure people understand this, is, so let's say this goes up in the constitutionality merits to the Fifth Circuit and the U.S. Supreme Court. The U.S. Supreme Court and the Fifth Circuit make some rulings, whatever they do. It's not like the case is necessarily done.
Correct.
Right?
Yeah. It would come back, and the preliminary injunction is just that. It's preliminary relief while the case pens, essentially. So, if we, for example, if the judge was to deny our preliminary injunction motion, we would, presumably very quickly try to appeal to the Fifth Circuit. We would ask them to decide it very quickly because we're under this 120-day window, wherein if that period ends, there's no putting the cat back in the bag, right? Because our clients and potentially millions of other Americans would be subject to the requirements of this rule. And so we would ask for hopefully some relief, before the 120 days to be completely to have some answer by then. But as you said, once the preliminary injunction stuff is kind of done, and that could go all the way to the U.S. Supreme Court. Once that's all done, the case itself comes back to the district court level, the trial court level, and they say, okay, now we've determined that the preliminary injunction is going to press pause on the rule. Will we move forward? How are we going to go forward on this rule? And there could be anything from more motions, more briefings, potentially a trial. There aren't really questions of fact here that a jury would weigh, but that's kind of when that process would go. So it's a very confusing and lengthy legal process, but I think for what most people are going to be interested in would be these preliminary injunction proceedings at the front end. So
your lawsuit is not the only lawsuit that's out there. There's a number of other lawsuits. Do you have a sense for, is everybody doing more or less the same thing? Are there some discrepancies between lawsuits?
The, again, general underlying theme and the relief that's sought, which is setting aside the rule, is a constant throughout all of those suits. So, I think at the end of the day, we're all kind of rowing in the same direction. I certainly can't speak to all of them out there, but, I think as a big picture, a big ticket item, they're all very similar.
You file this lawsuit. Are you going to win?
Yes. No, certainly can't guarantee an outcome, but and never would. But I think we, again, as I said, I think the case law is on our side, the precedent's on our side. I think we put together a very good case, and I hope that the justice system confirms that for us at the end of the day.
What do you want to put out there, or what gaps have I left that you think it's important that folks know?
I think it's just, pay attention to what's going on and coming out of these agencies. This rulemaking document was a 300-page document. It's published in the Federal Register. I think most people don't realize that every single day our government, sometimes multiple times a day, our federal government is publishing an administrative register. Same at the state level. There's a weekly administrative register here in Wisconsin, for example, that tells you what all these agencies are up to. And they're writing laws, and these laws affect your life. In the forms of rules, and they affect your life, and they could force you to do things that you don't want to do, and you might not be required to do them. They could be unlawful, and without everyday Americans who are paying attention and willing to stand up and fight back, nobody's going to be able to stop them.